there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome to the show. I'm your host, Daniel. And today is Judge J Cedric Simpson. Another one of my favorite judges that don't take no crap from anybody. But let's get started with Judge Simpson. Yes, I'll be here. Yes, I'll be here watching, but I'll be watching so I don't get stuck by ads. So let's get started with Judge Simpson. Make this bigger. I'll be here, but I will have my mic muted. So here we go.
Sir, it doesn't, you seem to want this process to work away, it doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied. You can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. If you know that wrong.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry. I'm here because I'm told to be here today, Your Honor. That's all.
I know.
So what I want to do
Kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes,
this?
yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery.
But if you wish to
The
be
judge isn't
represented by an
holding back
attorney,
here.
the court will
Imagine
afford you that
thinking you're killing
opportunity
it,
to be represented.
only to get
You
roasted in
understand?
Trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage,
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress? under Miranda?
If you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. No.
Have you asked them, how do I get discovery?
No, I will be doing that.
You ask anybody how to get discovery.
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just represent myself over here.
This is going to be a long process if you just are throwing stuff out there.
I'm really, I tried to prepare my best for this. I'm really.
Okay, this was your best? Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon?
What do you think, guys? Is this brave self-representation,
Okay, that doesn't happen.
or just a disaster waiting to happen?
I don't know what
Drop your
discontinue
take in
all
the
hearings
comments.
mean. What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do?
home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and he wants to talk to you. Then, yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah,
and maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could go go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess. State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant, as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that, as the court is well aware depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No. Motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I received a request.
Quick legal note. Resisting an officer is no joke. It can mean jail time, hefty fines, and a permanent record. The judge is basically warning him this is high stakes.
Responded that request was unclear, but it appears to be that the people executed a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within. I really would be
grasp the defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of the police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to, first of all, subpoena him to get his witness statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, that is, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion is denied. Yes.
Thank you.
All 3 parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
Understood.
Okay. Number 5 was that the defendant is requesting the report produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point. Like, don't.
It's denied.
Thank you. Number 6, the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not.
What does that mean?
Another motion down in flames. This is like watching someone bring water pistols to a legal battlefield.
Well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly afterwards.
You have to file a motion. You have to lay out specifics as to how and or another any statement that you made which it doesn't sound to me like was the subject matter of necessarily an in-custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you, Your Honor. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay. I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
to
videos.
respond to any piece of this.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure, that's what I was, yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's a disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have a hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir.
Here's a cliffhanger moment. Will he finally take the lifeline and get an attorney, or double down on chaos? What would you do?
I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for an adjournment in order to review the discovery materials I produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the documents.
What does that mean?
It means I just got the documents and I haven't been able to review them, and I need time to review them. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment.
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
And there it is. When a judge questions your competency, you know your courtroom strategy has officially hit rock.
Thank you.
In your record, I put email address that contact for discovery. I'm supposed to know place here and pick up. He's indicated he doesn't want to communicate about his case.
He doesn't want what?
Oh, at my moment.
This is the garden hose nozzle my team
Brandon Wilson and or Kimberly Slate. Jessica Bradshaw, I see you in Zoom. Ashley Glidden for the state of Suzanne Tehoffman. Latoya Leitner, I see you in Zoom.
Welcome to the 14th District Court. I'm the Honorable J Cedric Simpson, and I am about to provide to you a little information regarding this current and other landlord-tenant. This is the landlord-tenant or summary proceedings document, and you are here for a pre-trial. Your landlord has made allegations or claims that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for a lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and Ypsilanti Township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at the first appearance or in writing 5 days after the first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after the first being advised of these rights and information. You have the right to rental and other housing assistance. Within 5 days of the first receiving these advice of rights and information, you must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mich.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 734-961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is area code 734-973-4540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 734-544-6748. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside of court. Michigan and local community dispute resolution programs are a possible resource. The Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. To protect your credit and future rental possibilities, your case may be resolved by way of conditional dismissal in lieu of a judgment, if that is approved by all of the parties and the court. It is important that you understand these rights. If you have any questions, please feel free to address the court during your hearing.
Watch what alcohol does to stuck poop.
If your belly blows up like a balloon every time you eat, you have what doctors call a poop trap. It's where 15 pounds of poop is stuck in your body right now. But when you do this for 7 seconds, it all comes out.
This is the quickest way to clear out stuck poop.
Look at this. Everyone knows the colon has twists and turns, right? But what nobody talks about is this specific bend right here. Doctors call this the splenic flexure, but I call it the K-bend. It's the sharpest turn in your colon and exactly where poop gets stuck for millions of people. Here's what nobody tells you. This isn't just another curve. According to the Cleveland Clinic, this sharp bend is one of the most common places where waste and gas gets trapped, leading to bloating, pressure, and constipation for people everywhere. Watch what happens. When poop hits this K-bend, it has to make a hard turn. And unlike the other curves in your colon, this one acts like a speed bump that brings everything to a halt. The longer poop sits in this K-bend, the more water is absorbed from it, making it harder and drier, so it gets even more stuck. See, poop is like cement. As long as it keeps moving, it stays soft. But when it gets trapped at the K-bend, it hardens fast. And when 5, 10, even 15 pounds of waste backs up behind this blockage, your belly has nowhere to go but out. That's why you're bloated even though you barely ate, because your K-bend can't soften and push through the hardened poop on its own. And here's the worst part. Fiber makes it worse by adding more bulk to the traffic jam. Laxatives only push liquid around the blockage. Nothing actually gets your colon moving again at the K-bend. And the longer you wait, the worse it gets, especially as you get older. That's because your colon's muscles slow down as you age. That K-bend that might not have given you trouble when you were younger, it's now trapping more and more waste. Meanwhile, all that backed up waste makes you feel bloated, exhausted, and like you're carrying around extra weight. So what actually works? New York's top gastroenterologist, Dr. Gina Sam, discovered a simple 7-second morning ritual that finally solves the K-bend problem. First, it softens hardened waste right at this critical junction, then restores your colon's natural wave-like motion to push everything through the K-bend, so you can clear up to 15 pounds of stuck poop and finally create complete, satisfying eliminations every morning. The result? Flat belly instead of that bloated, backed-up feeling. Dr. Sam has made a short video where she'll show you exactly how to use this 7-second ritual from the comfort of your own home. Click below now to see exactly how to clear your K-bend in just 7 seconds a day. It's just a quick video that shows you exactly what to do. You won't have to put in your email or anything like that. Hey, don't let another day pass while you're backed up and uncomfortable. And don't let this hidden K-bend keep you dependent on laxatives, embarrassed by gas, and too uncomfortable to enjoy life. Click below now to discover the 7-second solution that's already helped thousands of people finally clear their K-bend and feel light and empty.
Best way to fix prostate problems? Saw palmetto? Nope. What about Flomax? Nope. Antibiotic? No. Here's what actually works. I'm going to show you the hidden reason you keep getting up at night to pee and why nothing has worked so far. Look closely at this model of your prostate. Your prostate sits right under your bladder and it wraps completely around your urethra, the tube where your pee comes out. See how it's shaped like an O-ring? It circles around your urethra like an O-ring around a garden hose. This part stores your urine, it's the bladder. And this tube running through is your urethra. Pee travels out through here. Now watch this. When your prostate is healthy, the O-ring grip is loose. You get easy, full flow. But when your prostate gets swollen, the O-ring tightens around your urethra, cutting your pee flow down to a slow trickle. That's why you're standing there waiting for your stream to start, still dripping after you zip up, getting up 5, 6, even 7 times a night, feeling like you never fully empty your bladder. And here's the scary part. Every night that O-ring gets tighter and tighter, like someone's tightening a belt one notch at a time. And if you ignore this, it only gets worse. Some guys end up wetting themselves, can't make it to the bathroom in time. Others end up needing risky surgery that can leave you with a broken morning salute and leaking urine. Now here's what doctors don't tell you. According to research from Harvard, the reason your prostate swells, making your O-ring clamp down on your pee flow, comes down to bad bacteria taking over. See, your prostate is supposed to have good bacteria that keep it healthy and keep that O-ring loose. But when bad bacteria take over, often after taking antibiotics or even just getting older, your prostate swells up. The more swollen it gets, the tighter your prostate's O-ring squeezes around your urethra. That's why you keep waking up at night, dribbling in your underwear, and feeling like you can never fully empty your bladder. Once the good bacteria are wiped out, yeast and harmful bacteria move right in, making your prostate swell even more. Meanwhile, most doctors keep prescribing pills like Flomax and DHT blockers. Sure, Flomax relaxes muscles so you pee easier for a few hours, but it doesn't stop the swelling. So your prostate, that O-ring around your urethra, stays tight. DHT blockers might shrink the prostate over months, but they'll crush your testosterone and kill your sex drive, which means you'll keep coming back for more pills without ever loosening that O-ring that's strangling your pee flow. Look, I go to medical conferences all the time. Last year, Dr. Kyle Stevenson, top surgeon who's worked with the Boston Celtics and Harvard Athletics, showed us something different. He'd figured out how to actually loosen that O-ring without pills or surgery. Takes 30 seconds, does 3 things. First, kills the yeast and bad bacteria so the swelling goes down. Second, releases your prostate's O-ring grip on your urethra so pee flows like you're in your 30s. Third, restores your good bacteria so you're not back here in 6 months with the same problem, and lets you finally sleep through the night. I've made a short video where I'll show you Dr. Stevenson's exact 30-second O-ring release method so you can finally sleep through the night. Click below now to watch. No email required. It's super quick and shows you every step. Listen, don't wait until that O-ring is squeezed so tight that barely anything gets through. Some men end up needing surgery, and trust me, it doesn't always go well. Up to 40% of men lose their morning salute after these procedures. Don't let that happen to you. Click below now to learn Dr. Stevenson's 30-second method that's already helped thousands of men loosen that O-ring and finally sleep peacefully through the night. Because 3 a.m. is for sleeping, not for peeing. Take back your nights and your life.
Fourteen District Court of County, Washington, State of Michigan, now back in session, Your Judge J Cedric.
May be seated. Court does call the case of Arbor Woods versus Rachel Sibbeth.
Good afternoon, Your Honor. Casey Matson, 7729 on behalf of plaintiff.
She is not checked in. I think we did have you previously sworn. You may proceed.
Thank you, Your Honor. This is a motion for entry of an eviction. A default or a judgment was entered on March 10th. A default judgment was entered for $2,731.73. Defendant failed to pay that amount and has not paid any amounts towards her rent since then. So right now the balance is over $7,800. We are asking for entry of an order of eviction.
Hearing no response and on the merits, the court will sign the order granting plaintiff's motion for issuance of an order of eviction. And I've signed the order. I don't think I have. And I also do have the writ. We will sign off on that. All right. Thank you. Court calls the case of Arbor Woods versus Brandon Dixon.
Not checked in, right?
They are not checked in. And this is their motion, I think, to stay the eviction. His motion.
I need to.
It is.
Yes, Your Honor. Casey Matson for the plaintiff.
All right. The court Court upon, the court upon reviewing the motion and the Mr. Dixon not appearing, the court will enter the order denying defendant's motion to stay the order of eviction. The eviction may proceed. And I've signed off on that order that was sent by the defendants.
Thank you, Your Honor.
Thank you. I'll need that. Arbor Woods versus Leticia Johnson.
If you're turning 65 or beyond, you're going to
And go ahead. I'm sorry.
Sorry, Your Honor. Casey Madsen for the plaintiff.
And their sidekick, Adrian. Hello, folks. State your name, please.
I'm Leticia Johnson.
Adrian Johnson.
All right. Okay, where are we on this case?
Your Honor, at this time, all of the repairs have been completed. We do have a proposed agreement for the Johnsons. If I was able to go into a breakout room with them and discuss, we weren't able to get a hold of them before court today.
Okay, the problem's going to be that they are here.
Or if I could give them a phone call.
Yeah. Pardon? You want to give them a phone call? Do you have their number?
I have a number. I don't know if that's the number that the phone that they may have on them. It ends in.
I have. I have.
What's the last four digits?
Oh, of the phone number I have, it's 6076. Sorry, Your Honor.
That's the one that you have?
Yep.
Okay, I'll pass the matter, and as soon as she's done with her cases, she'll give you a call.
Okay.
And you can use the rooms, the vestibule rooms out there. Okay?
Thank you.
Thank you.
Your Honor.
Arbor Woods versus Brandon Wilson. And Kimberly Slayton. Wilson, Slayton, they are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. There is rent to retain of $1,884.65. Cost of $242.00 for a total of $2,126.65. We'd be asking for it to issue after October 6th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northville Crossing versus Jessica Bradshaw. Okay, hello, Ms. Bradshaw. Okay, what is the claim now in this case?
Oh, it's been ongoing, let's say that.
Okay.
Your Honor.
Oh, go ahead.
Yes.
Your Honor, I have rent to retain of $1,012.77. Court cost of $190 for a total of $1,202.77.
Okay. And so you made your $350 payment.
I actually paid $400 instead of $350. I did do that. I did get a denial from the SER, and I got a phone call from them stating they needed a updated court ledger, which obviously they couldn't give. I called the courts. They couldn't give an updated one because the amount when it was processed was at that time only for the 900, but because when I put in for the SER, because it was for the full amount, because there was 2 months worth of rent. So they denied it. They said to get something from Northville Crossings stating how much the full amount was, to reapply, send in all the proof from Northville Crossings with that updated amount. So I did all of that. I got a phone call yesterday from them. They denied it again.
Jeez.
Yes. And they said, because one, I make too much money, and two, the amount was what they say. Your shortfall amount is equal to or greater than the amount needed to resolve the emergency in this emergency. That's why they denied it. But I do have an appointment with Hawk on October 6th at 12 p.m. with Autumn from SOS.
Okay.
Yeah.
Go ahead.
Yes.
At this point, we would be requesting entry of a judgment. At this time, that is the third hearing now.
No, I understand. Ma'am,
Yes.
if you had just this amount and had to pay it off, how long would that take you to do?
I get paid on the 3rd. I don't know honestly how much it's going to be. Like I told you, not last time because I was in surgery, which I will be in surgery on the 3rd again with the other doctor that I work with. I've been working as many hours as I can, filling in at another office as well, to make up hours so I can try to get this paid off. So hopefully I get as much money as I can on the 3rd. I honestly, I don't know how much my paycheck's going to be. Like I
All right.
said before, I
gotcha.
didn't plan on having surgery to have my gallbladder out. That's what sent me behind.
Understood.
Drinking warm water before bed.
So here's what I'm going to do, and I'll explain why I'm going to do it. I'm going to issue a judgment to the plaintiff, finding no tribal issue after hearing in this case. All right. For the total amount of the $1,202. What that does is that, in essence, to save your tenancy, that's the amount that you'd have to pay.
Okay.
If I adjourn it out, we're going to have to deal with October rent.
Right.
Got it. So, what I will do is, over plaintiff's objection, I'll extend it slightly. Normally, you would have until the 6th to do it. I'm going to, a writ would issue the 10th.
Okay.
And again, that's over plaintiff's objection, but I'm going to give you to the end of that week
To see what Hawk
to
says.
try to see if you can figure it out, get it paid.
Okay. I really appreciate that. Yes, I am trying. I really am.
No, you are. And and you came through and you paid more than what you told me you were going to pay. I get it, but I think this is probably the safest way we can try to see if you can find a way to maintain your tenancy, okay?
Yes, absolutely. I do. I appreciate it very much so, Judge. Thank you.
Thank you. All right, you have a great weekend.
You too. Thank you.
Farms versus Melanie Clemens.
Mr. Matson for the plaintiff.
Melanie Clemens, they are not present. You may proceed.
Thank you, Your Honor. This case, we were actually waiting for a payment to clear.
Right.
It hasn't come back yet. However, based on the recent chargeback for the $3,000 that is being requested, we are requesting another adjournment just to allow for the full period of time for this payment to clear. So
okay.
To give it the entire 10 days.
Okay. I do not have next week, so I will adjourn it out to October 10th, 2025 at 3 p.m. And has that chargeback been verified? I mean, I know there was some dispute. I don't
think so, Your Honor. I do have Patty on.
So from what we heard.
Yes, go ahead, Patty. I'm sorry.
Okay. You're okay. From my conversation with Melanie was that the owner of the credit card actually did not know what was happening or why there was a fraud alert on it. And he was working on contacting the fraud department to let them know it was an accurate charge. That was, as of Wednesday, was the last update I had from her.
Okay. All right.
Oh, well, we'll see. All right, we'll put it out to the time. Thank you.
Thank you, Your Honor.
Is that it for Patty? Yes, it is. Valley Ranch versus Latoya Leitner.
Lucy Matson on behalf of the plaintiff.
There. Okay. Ms. Leitner?
Yes, sir.
All right. I granted a judgment for possession. This is your motion?
Your Honor, this is plaintiff's motion.
Plaintiff's motion. All right. Go ahead with your claim.
Your Honor, we are asking for reissuance of the order of eviction. The order of eviction was previously entered on May 28th. However, Ms. Leitner had ended up paying the amount, so we had not proceeded with the writ. However, one of the payments that she made to satisfy the judgment has now been reversed. So in light of that, the judgment is now not satisfied, and we would ask for reissuance of the writ. And at this time, no other payments have been made. There's a balance of $8,596.46.
Ms. Leitner, what do you have to say to that?
So, as far as the payment being reversed, I didn't even know in June that it had been reversed until I went to pay my July rent. I'm currently not even in the state. I'm working out of state. I have been since I got out of recovery from my surgery in June, and I don't even have access to pay online anymore. They want a cashier's check in person, but I've been working 7 days straight. I have not been able to get back to the state.
Okay. And you're saying that you have this amount?
Yes, and I don't have any family in Michigan that I trust enough to go to my banking institutions.
Your Honor, we would object. I mean, that's almost $9,000.
No, I hear you. I'm just saying, but I'm trying to figure out.
And the reverse payment, I contacted my bank, and I'm still waiting to hear back on why it was reversed. It hasn't shown back up in my bank account. I didn't issue a fraud alert.
Okay. Well, ma'am, what I'm going to do this time is I'm going to grant their motion for the reissuance of the writ of restitution. I'm not sure exactly where you are, but what you'll have to do if you want to resolve this is somehow or another you need to get back into the state and certainly pay the amount of whatever that reversal is once you sort that out. But at this juncture, I am going to grant their motion, reissue the writ, and I've signed that. I've signed both the order and the writ today. Right. Okay. Thank you.
Do I know how long I have?
Well, there's a 72-hour, for months it's posted, there's 72-hour wait. But I'd say the best I can tell you is you're operating on borrowed time.
I understand that, Your Honor.
Okay. Thank you.
All right. Thank you.
Northfield Crossing versus Suzanne Tehovnik, I think it is. That matter is dismissed on plaintiff's motion without prejudice. And I will let you make that call. I'll stand in recess, and then once you guys are ready, they'll come back in and you let us know, and then we'll call it back. Okay?
Your Honor.
Thank you.
You don't know what an AI work management platform is? Yikes. Here's 3 new AI-powered changes to the Monday platform in 2026 and what they actually mean. We all know we need to use AI.
I'm just going to do a quick check-in. When I call your name, please let me know if you're here. Melisha Tate, Vicki Bennett.
She's on Zoom.
She's on Zoom. Oh, yes, I do see her. Markayla Jennings, Kayla Smith, Ruth Palmer, and or Denisha Moore. Yeah. Oh, Ruth or Denisha? Ruth. Maritza Herrera, I see you in Zoom. Jonathan Henderson.
Here.
Here. Natasha Olmos, Teron Weatherspoon. Oh, I see you in Zoom. Tiffany Roots, I also see you in Zoom. Tisha Clark, Giovanna Nesmith, Melinda Ostrander, and Regina Agnew.
Welcome to the 14A District Court. I'm the Honorable J Cedric Simpson. And I'm about to provide to you valuable information regarding this current and other landlord tenant. This is the landlord tenant or summary proceedings document, and you are here for a retrial. Your landlord has made allegations of claims that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for a lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. In these proceedings, you have the right to have your case heard in proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and its surrounding township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at the first appearance or in writing in 5 days after first being advised of these rights and information. Jury must be paid when the demand is made or within 5 days after first being advised of these rights and information. You have the right to rental and other housing assistance. In 5 days of first receiving these advice of rights and information, you must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mich.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as all can be reached at their phone number, area code 734-961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is area code 734-973-440. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 734-547-6748. You do not need a judgment to obtain assistance from any of these agencies. The sounds of the complaint are sufficient. You have a right to reach an agreement outside of court. Michigan and local community dispute resolution programs are a possible resource. The Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. To protect your credit and future rental possibilities, your case may be resolved by way of conditional dismissal in lieu of judgment, if that is approved by all the parties and the court. It is important that you understand these rights. If you have any questions, please feel free to address the court during.
What's your name?
14A District Court for County of Washington, State of Michigan is now back in session. Judge J Cedric Simpson presiding.
You may be seated.
Watch what magnesium does to your bowels.
If you have to wipe more than 4 times after you poop, here's why.
The Mayo Clinic confirms that stuck poop can cause these embarrassing skid marks in your undies. You see, when stuck poop causes a traffic jam in your colon, your bowel...
Court does call the case. Arbor Woods versus Johnson. There she is. Pardon?
Adrian had to get the kids from school.
So you sent him away.
Yes.
All right, no. Go ahead. All right, Ms. Mattson.
Good afternoon, Your Honor. Thank you. Tracy Mattson on behalf of plaintiff. Your Honor, I did have a chance to speak with the defendants. We did come to a proposed consent judgment agreement. The rent to retain is $1,413.68. Court costs of $224.00 for a total of $1,655.68. We did agree that that amount is to be paid on or before October 6th. We had originally agreed to the 3rd, however, upon the court rules, she would get until the 6th to pay that balance, and then October's rent by October 17th. I did speak with them both. I advised them of their rights under MCR 4.201J, and I got their permission to sign. However, Your Honor, since second defendant has left, if we could enter this by hearing or...
Yeah, so you can issue I'll issue with all the understanding that they did have their rights, I'll just enter it by hearing.
Thank you, Your Honor.
All right. Ma'am, is that all correct?
Yes.
All right. Did you have any questions regarding the terms of the consent judgment?
Yeah.
No? All right. Court will enter the judgment for the 1655-68, finding no tribal issue after hearing along the terms and paying it by the 6th, with October rent being due to 17th.
All right.
All right.
Thank you.
Fantastic. Thank you. You have a great weekend. And tell him to have a good weekend too.
I will.
All right.
Thank you, Your Honor.
Thank you, Ms. Manson. Have a great weekend.
You as well.
Avalon Housing versus Vicki Bennett.
Good plan.
Good afternoon, Judge David Morris on behalf of Vicki Bennett, who's appearing by Zoom.
Ms. Bennett? Oh, there she is.
Yes, sir.
Hello.
Hello.
All right. Where are we on this one?
I think we have to ask Mr. Morris.
You're on a proposed consent judgment was circulated earlier today. Ms. Bennett had a emergency medical appointment today, so I didn't have enough time to go through those factors. Or when I did discuss it with her, I was not convinced that we were fully understanding all the terms. So I think if Your Honor will pass this case, I can try calling Ms. Bennett again, or
okay, that's what you want to do.
That's fine. That's fine with the
I'll pass,
Your Honor. Thank you.
All right. Ms. Bennett, I'm going to pass your case. Your attorney's going to give you a call.
Your Honor, sir, I almost died Wednesday of respiratory failure. I have a ventilator in my home. I just want to let you know there's other situations. Thank you.
All right. Thank you, ma'am.
It's coming.
that's
Your Honor, can we just adjourn it for 2 weeks?
Adjourn it.
And hopefully we'll just send in an order.
Okay.
You're not here next week, right?
I'm not here next week. So, Ms. Bennett, what we're going to do, given all of the circumstances, council has agreed we're going to adjourn this out till October 10th,
I have all my
2025.
rent money in a savings account in my bank. I just want to get work orders done. And that's what I have to say. I just hope I stay alive till then. Thank you.
All right.
she's escrowing the funds, Your Honor.
Yes, I get what she's indicating. So I'll adjourn it out to the 10th, 2025 at 12 noon.
Thank you, sir.
And hope, all right, thank you.
Right. Keep it coming. Thank you, buddy. Bye-bye.
Thank you, Judge.
All right, thank you. Evergreen Apartments versus Markelia Jennings.
Jason, for the plaintiff. Ms. Jennings is making her way to the lectern, Your Honor.
Your name?
Markela.
All right. The total claim is 217909. She has a plan, but it doesn't include having everything paid within the statutory period. We've offered a 1 week extension. She's still uncomfortable with that, but that's the best I can do.
All right. Yeah, what did you want to tell me?
Well, I get paid. the 3rd and the 17th, but I won't have it by the 13th because I don't get another paycheck till the 17th. I could pay the $21.79 by the 17th, but not by the 13th.
What about October, Trent?
I get paid October 31st, so it's 3 times next month, but.
All right, so you have 3 paychecks in October, is the deal, right? And how much is owing?
$21.7909.
I think I've heard it somewhere. $21.7909.
I never put it away. It just stays on my.
All right. On the 3rd, how much were you intending on paying?
$1,200.
$1,200? And so then it's really about $1,000 balance. And then what were you going to do on the 7th? How much were you going to pay on the 17th?
The rest, whatever's on for the rest of October.
None of October's rent?
It will be October's rent. It'll be 0. Because this is the 3rd, the 17th, and then the 31st.
No, I said on the 17th, how much were you going to pay? You said on the 3rd, you were going to pay $1,200.
Yep, I'm going to pay $1,000.
Pardon?
$1,000 on the 17th.
And then $1,000 on the 17th.
And whatever else by the 31st.
Here's what I'm going to do, because otherwise you're going to be brought back to court in October if you don't pay it.
Okay.
So I will enter a judgment. I won't do it as an order of conditional dismissal that basically indicates the 2,179.08 would have to be paid as follows: $1,200 on October 3rd, an additional $1,000 on October 17th, and October's rent, including all late fees, by October 31st. If at any of those,
Well, not by October 31st. I get paid on the 31st, so
it's got to be
on the
paid-
31st.
It's got to be paid on the 31st.
Right.
All right. If any of those payments are missed, a writ may issue. So you understand that, ma'am?
Yes.
So I'm giving you time to pay it out, but you've got to make sure you make all of those payments.
Right.
All right?
Okay.
And we're including October rent in consideration of giving you that additional time.
Okay.
You understand that? Okay. I'm going to do that by hearing, finding no tribal issue and issuing that.
So I don't come back to court until.
You don't come back to court.
Okay. Thank you.
All right.
Your Honor, so seems like I should leave the redemption date as the 6th.
Correct.
Because she would have till then anyway.
Right. She would have until the 6th to get it paid. But if any of the payments are missed, then an order of eviction can occur.
Thank you.
Thank you, Your Honor.
All right. Thank you. Court calls case of Evergreen Apartments versus Kayla Smith.
James Sneak for the plaintiff.
Oh, she's here. What's your name? All right, where are we?
She owes $692.37. That includes costs.
$692.37. All right. How are we going to get this paid?
I'm going to pay it next Thursday.
You're going to pay it next Thursday, which will be the 1st or 2nd.
Redemption date of the 6th set aside if paid?
Yes. So what I'm going to do is, finding no tribal issue, I'm going to issue a judgment for possession in that total amount with a writ to issue the 6th. They'll set aside the judgment if you get it paid by that date. Sound good?
Yeah.
All right. Fantastic. Thank you, ma'am.
Thank
Have a great weekend.
Yeah.
I guess I should sign that. Court calls the case of Evergreen Apartments versus Ruth Palmer.
I have a note that says she was going to pay by noon today.
Yes, I was at CVS all day. Something's going on with my card that the money is on, and it's not going to be corrected until Monday.
Total is $2307.96.
And ma'am, I don't know what you said, but I do have the note in my file indicates that you were going to pay this all off.
Yeah, so that was my plans, but I've been at CVS all morning trying to get the money off. And then when I contacted the card people, they said that there's something going on with the card system itself and it won't be corrected until Monday.
Sounds like the 6th will work for her.
Yes. So I don't have a sticker in. Judgment to the plaintiff by default or finding no triable issue after hearing for that total amount with a writ to issue the 6th.
Thank you.
Yeah, I'll take it.
Okay, you understand that, ma'am?
Yes, sir.
All right. Good luck. Have a great week.
Thank you. Well,
Calls case of Glencoe Hills versus Yaritza Herrera.
James Singh for the plaintiff.
She's here by Zoom. There she is.
Here. Hello.
Hello. Okay, and where are we now on Herrera's case?
She owes $965.49. Looks like she still has an app pending. If Miss Amy can confirm that with Miss Herrera's permission.
Miss Amy's not with us today.
Well,
so she has a half payment?
I made a payment today.
yeah, actually, the amount I have is less than the ledger amount, so I think that's right. So her balance now is
80.
Hang on.
965.49. She paid $580 today.
She paid $580?
Yes, sir.
So the number you gave me of the 9, did I take that off of there or it's already
that's already been the 580 has been deducted from the 1545.49.
Got it. Okay.
My wife stopped trusting me because I
So Ms. Herrera, I know we've been working on this. When are you going to get this paid off?
Stressful. Yes. So I've been working still with the Social Security and Section 8. I don't know what to do about Section 8. Nobody in the office is listening to me. I've sent them bank statements that shows that loss of income. I have also went into Social Security and spoke to them in person where they called my specialist at Section 8 and told them that she did lose that income and they're still not adjusting that. So
Who administers your Section 8?
Jacqueline. And then Misty is the supervisor. So I haven't been able.
What company that is? Or is it through Mistia?
I don't know what you mean.
Ms. Herrera, is that Misty Hendershot from the Housing
Yes.
Commission?
Yes. Okay.
And they spoke to Jacqueline, Social Security spoke to Jacqueline on the phone and told her that she did lose that income for her son over the phone because they're confused of my bank ledgers and what I actually lost. This is going back from May, and they're not adjusting what I should be receiving from them.
Got it.
But I told Social Security that although I have disability restrictions, I need to work. I need to work to get this taken care of because it's going on for too long. And they gave me a ticket to work where I'm still getting Social Security, but I can work and I have a job. I started working. I'm a dental assistant, so I have that income that's going to be coming in. So next week I'll be getting Social Security.
Okay, Ms. Herrera, let me ask you this. How much is your monthly rent that you
$520.
Plus utilities.
Plus utilities. So let's we just ballpark it at the 6th, because something's gone. And this is the same thing you've been saying all along.
It'll be 1582.47 on the first, adding in utilities and
your October rent with the utilities. So we're talking roughly around $600 or a little bit more. When can you get that paid?
Well, I always make my portion of the payments.
No, I know,
So that's
but there's a reason why I'm asking it that way, Ms. Herrera.
Okay.
So what date can you get that portion paid?
On the 3rd.
On the 3rd. Okay. Somehow or another, you got to also whittle away at this 965 until you get everything straight. So how much additional can you pay prior to the 10th to be that next week? Is there anything that you're going to be able to pay?
I cannot say because I'm in clinicals right now and I don't know if they're paying me next week or the following.
Following week. Okay. I got
And
you.
then I do have Hawk. Hawk has approved me, but they don't have the fundings yet until October.
I remember you telling me that also. All right. So here's what I'm going to do. Because I think you're working at everything, trying to get it done, and it's just not happening. So I'm going to adjourn this out to October 10th, 2025 at 12 noon. You need to make sure you pay your October. Yes, ma'am.
I was going to say, because I am in the clinicals, I have to be there in the office, and I do not get out until 2:00 on Fridays.
On Fridays. Gotcha.
can we both just appear by Zoom at 3 if we're going to be at?
Yeah, I'll make a, can we arrange to do it? All right, so here's what we're going to do, Ms. Herrera, because I know you're doing everything. I'm going to set yours at 3 p.m., which is a special time. You can appear via Zoom.
Thank you.
And we'll just see where you are, but make sure you get your October rent in, okay?
Yes.
So that this balance stays about where it is until we can get that other part corrected.
Yes, I'm trying. That's why I was able to make the payment today. I got an increase on my credit card and was able to make the $580. So,
Okay.
and then I've got that ticket to work with Social Security. So, although it's against what my doctors are telling me with my conditions, I have to work at this point because no one is really trying to help me with Section 8, and I need to have that extra income. So thank you for listening to me.
Not a problem, Ms. Herrera. All right. Above all, just make sure to take care of yourself. You hear me?
Fine. Thank you.
All right. We'll see you on the 10th, 3 o'clock.
Okay. Thank you, Your Honor.
Thank you.
Thank you.
Gulfside Lake 3 versus Jonathan Henderson.
Yes, thank for the plaintiff.
Hello.
Mr. Allen.
Your name? Your name?
Jonathan Henderson.
All right. And how much do we have owed today?
307,731. We have a consent.
That's right.
If you're getting ready to go on Medicare, here are 5 mistakes that you want to avoid. And trust me, you do not want to miss mistake number 5. Mistake number 1 is missing a very critical enrollment opportunity. Did you know that there's a unique once-in-a-lifetime chance to join any plan without any medical qualifications? And that period begins on your Medicare Part B effective date, and it lasts for 6 months. Now, mistake number 2 is selecting a plan based only on the monthly premium. Don't fall.
Okay, and he's going to get this paid by the 6th. Okay. Sir, you signed this consent judgment?
I did.
All right. You have any questions regarding its terms?
So if the payment is not made by the 6th, I wasn't aware that they're there were other options. I just kind of signed the first thing that was given to me, unfortunately. But if the payment's not made by the 6th, what are the other, what will happen?
Well, what this judgment indicates is that you're going to pay it by the 6th.
Yes. I'm just curious.
Well, the only other option would be to move on from these terms.
Okay. I'm not, like I said,
No, I got you, but
yeah.
Are you not going to have it? What?
Right now I'm making steps to get it, but it's all like, I was listening to a young lady's testimony prior to this, and I'm kind of slightly on the same boat with that situation. I'm on long-term disability.
Is Ms. Herrera?
Yes. I'm on long-term.
Yeah, but there may be, I don't think you're in that boat.
Like I said, slightly. I'm just talking about in relation to just how I get paid. I get paid lately by long-term disability. That's been kind of held up for the last 2 months, and it wasn't. Hopefully, I remedied the problem today. It was just a situation of paperwork. But no, I just want that to be on record.
Okay.
So it is kind of based on. Last time it took a week for everything to come through. I have some things in play, hopefully. So that was all.
All right. Did you wish for me to sign this judgment, sir?
Not particularly, no.
So what do you want me to do?
Well, what were my other options?
You're not disputing the amount.
Oh, I'm not disputing the amount. I owe the money. It's just about what will my options be in terms of if you can do an adjournment until I've heard dates like 13.
I'm not on this case. I'm not going to do an adjournment. It's obvious that you have the.
May I have just a moment?
Yeah.
It's like, so you're not going to have it next week.
At this point, I'm just going with, like I said, I'm just trying to take care of the situation as best I can.
I'm sorry, sir. That doesn't tell me anything. Can you have it by the 10th?
Oh, yes. I can have it by the 10th.
May I?
Right. That's fine. So the judge, if it indicates that you need to pay it by the 10th, do you have any other questions regarding?
No, I understand. I would just, if I could get more time, it would just be appreciated. That's
and Mr. Fink explained to your rights under the court rule regarding 3-day rescission.
Not particularly. Oh, yes. In terms of if I'm not happy with this, yes, I did. He explained it.
But as the court can see, he's thrilled.
Yes. All right. I will enter that judgment by consent. All right. Thank you, sir.
Thank you.
Outside Lake versus Natasha Olmos.
She's not here.
Same thing for the plaintiff. The claim is $2,125.57.
I'm sorry, how much was that?
The total is $2125.57.
Not being here, judgment to the plaintiff, that is by default for possession. Redemption amount, any amount requested with a writ issue.
Thank you.
Avalon Housing versus Militia Tate.
Good afternoon, Your Honor. Jill Bauer here on behalf of Ms. Tate.
And I have a dismissal that what the parties are doing.
Yes, Your Honor.
So I believe you.
All right. Case is dismissed.
Thank you.
All right. Thank you. Hamilton Crossing versus Jessica Harrison.
James Fink, plaintiff.
Your name?
Jessica Harris.
Thank you.
The claim is $8,024. We had filed on her either last year or earlier
this year.
And either last year or earlier this year, there was a bankruptcy stay. She had a discharge. Since the date of the discharge, her balance is 8024.
And ma'am, how are you intending on getting that?
Oh, and I'm moving. I'm sorry.
It's okay.
I don't feel good. And I should be gone by next Monday.
So you're gonna leave?
Mm-hmm.
Okay.
I just came because the amount that they gave me was inaccurate. They were trying to charge me for rent
before the bankruptcy. And my attorney said that they can't do that. They can't charge me for the rent that I wrote off in bankruptcy.
I thought, Mr. Fitz, you said it was since bankruptcy.
We've reduced that since.
Yeah. Okay.
So what is the amount?
$8,024.
Okay. And I plan on making payment arrangements. Is what I discussed with Ms.
Yes,
Yakita
you can.
or
But what
Yakisha.
you can talk to them about making payment arrangements. I'm going to find no tribal issue in this case after hearing judgment to the plaintiff for possession.
Now, I do have a question though.
Yes, ma'am.
What about the repairs I had to pay because they have not been making any repairs? I haven't had a closet since October.
Oh, ma'am, this is for possession of the premises. So my understanding is you said you're leaving.
Mm-hmm.
Okay.
But I had to pay someone to make the repairs that they have not been making.
Okay, then what I would suggest is that as you look at this amount here as to what you will owe, that you work that out with the landlord in terms of.
Okay.
All right. Okay. The no tribal issue, writ they fixed.
Thank you.
Thank you.
And that just means that the police come on the 6th, or what does that mean?
What it means is they can file for an order for the court to issue that you would be forcibly removed from the premises if you had not moved.
Okay. I just need time to clean it, and I'm not feeling well.
I get you. Thank you.
Thank you.
You don't know what an AI work management platform is? Okay, let me tell you. Here's 3 new AI-powered changes to the Monday platform in 2026 and what they actually mean. We all know we need to use AI, but we're still figuring out how. Well, Monday.com figured it out. Number 1, Monday Sidekick. It's like your
Court calls the case of Hamilton Crossing 2 versus Trevon Weatherspoon.
I think Ms. Bauer is going to pop up on that one.
Yes, Your Honor. Jill Bauer here on behalf of Ms. Weatherspoon, who is also present.
All right. Oh, there she is. Okay, she needs to. Ms. Weatherspoon, you have to be stationary, otherwise I got to pass your case. She's not even hearing me.
This is an interesting one, Your Honor, may I?
Yeah, well, except that.
Waiting for Ms. Weatherspoon.
Is she stopped?
It looks like she stopped.
Oh, at a light. Miss Weatherspoon? She's still driving. I'm calling her while she's driving. I'm not going to discuss the case. Miss Weatherspoon, you need to pull over. I don't know if you can call her Miss Bauer, but she's still.
I will try to call her, Your Honor.
All right.
Ms.
Now go on.
Weatherspoon, are you hearing us? It looked like she looked at the phone.
Yeah.
Okay.
I'm having a feeling of deja vu with somebody driving in your courtroom.
So am I, which bad things happen when that occurs. So I'll pass it. You call her, see if we can get this taken care of. Court does call the case of Hamilton Crossing 2 versus Tiffany Roots. Yes. Ms. Roots? Okay, there she is. All right, what is the claim in this case?
Claim is $2,261, but I have prepared a conditional order of dismissal that she's seen it, but it requires her to pay the $2,261 in 5 equal payments of $376.33 and a final payment of $376.85 starting October 15th and going through March 15th of next year, and to pay her rent timely starting October 1st. This case will be dismissed. The requirement to pay rent can be enforced for 1 year. If she doesn't comply, we submit an affidavit of noncompliance. Judgment order of eviction with 5 business days for her to object. The 14-day period is waived.
All right. Ms. Roots, does that sound like something you want to do?
There is only one problem with that. I was told that I will have until the 5th to make the payment every month. Not that I'm looking forward to being late, but I don't start. So I did get a job. The job doesn't start until Monday. I was supposed to start last Monday, but they pushed the start date to this Monday. So I will not be, I may not have the entire
Got it, Judge.
October by the 1st. I am driving for Uber, but I'm not really making a lot of money because I have to rent the car in order to drive. So
Gotcha.
what I'm wondering is, is it possible to make a partial
So
payment?
you need to have your rent paid by the 5th as opposed to the 1st of each month.
Yeah, I've changed it to defendant shall pay monthly rent timely and in parentheses, no later than the 5th of each month commencing October 1st, 2025. And I am emailing that to the best court staff we're in front of this afternoon.
Okay, does that work for you then?
That works.
That works. Okay. And you have any questions regarding what the terms of those conditional dismissal would be? Any questions at all?
Is that something that I can read personally and then ask a question?
Go ahead.
Well, I'm here. I can ask the questions. What happens if there comes a time where I can only make a partial payment? Like if the 5th comes of October and I'm only able to make a partial payment, what will happen? Is it just going to go right into?
That means they can reopen the case and file an affidavit saying that's what you did in violation of the agreement. Submit to the court a judgment as well as the order of eviction, but you gave her a 5-day period to object to.
I did.
All right. But there will be a 5-day period where you would be able to say that you object to their reasons for doing what they did.
Okay. That's my only question.
Okay. You have any problem with us entering the conditional order of dismissal?
I do not, no.
All right. If the conditional order of dismissal meets those terms, do you give Mr. Fink permission to sign your name to that?
Yes, I do.
All right. Ma'am, I would advise you, since you're unrepresented by counsel, you had 3 business days to think about it from the time of my signing. If you believe that there's some misunderstanding, some confusion on your part, some legal reason, or some right you didn't assert, you'd have to file a motion with this court within 3 business days. You understand that?
I understand.
Okay, very good. I will mark this file as conditionally dismissed. Ma'am, have a great weekend.
You too. Thank you.
Thank you.
Thank you, Your Honor.
Ron Vista versus Tisha Clark. Oh, he's doing that. Ma'am, what's your name?
Tisha Clark.
Yeah, we may have a COD worked out, but I need to check my email real quickly.
All right, very good.
She's been working her way through the terms of the COD. She's already made 3 payments on time, which made her eligible for a rental reduction. And it looks like her arrearage is $841, and she will make those payments in how many equal monthly payments? 6.
Hey, we will get, I mean, if it's sure, but I mean, I probably could pay it before that.
So if you're comfortable, her arrearage is $841. We're going to do a COD that requires her to pay rent on time for a period and to pay that $841 in a period that she and the landlord will agree to. And if you are comfortable with those terms, and she is, if you advise her of MCR 4.201J, we'll hammer this out next week and submit the order with her signature and ours.
All right. Ma'am, would you be acceptable to that?
Yeah.
Okay. And I would indicate that you would have 3 business days from the time of my signing of the conditional order dismissal to if you believe that there is some mistake, some right you didn't assert, some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I'd set it aside, but you have that right to do that. You understand that?
Okay.
You have any questions whatsoever?
No.
All right. So we'll get her signature on it. I'll mark this file COD. I'll expect it next week. You have a wonderful weekend.
Your email address right up.
Right in this box.
Right in that box.
Weatherspoon's ready. I'm gonna call that.
Oh, why?
I'm gonna mess this up.
Don't do that. Sheena has it,
Sheena
though.
has it. Okay.
Yeah, Sheena has it.
In your honor, for the record,
yes,
Miss Tisha Clark is pretty awesome.
Thank you.
So noted. All right, you take care.
You too.
I'll recall the case of Hamilton Crossing 2 versus Weatherspoon.
Thank you, Your Honor. Jill Bauer from Legal Services here on behalf of Ms. Weatherspoon, who is also here and now part.
All right, very good. Thank you. All right, what are we doing on this case?
Well,
go ahead.
This is an unusual case in my experience, Your Honor. So Ms. Weatherspoon, we obtained 2 sources of rental assistance for her, and her balance was paid in full, but she still owed September rent, and she talked to the office about doing a payment plan and had terms of a payment plan that we thought we were all in agreement with. And today, while I was Miss Inget and I were trying to get the terms of the COD in writing so that we could submit it to the court, I was told that Ms. Weatherspoon had moved out and surrendered her keys on September 19th. So I talked to Ms. Weatherspoon about this, and my understanding of what happened is Ms. Weatherspoon's partner was murdered in July. The people that are being investigated for killing him some of them live in Hamilton Crossing, or associates of them live in Hamilton Crossing. They've been harassing her. She's felt very unsafe. She has young children. So she went to the office to ask to be moved, and she was presented with a VAWA form to fill out, which she submitted along with a police report about the harassment. And she agreed to surrender her keys on the 19th. Now, she didn't know that this meant she was giving up her rights to her housing. She thought this was a process that she had to comply with to be moved to a new place. And so she was she did turn in her keys and she did sign that paperwork, but she did not understand the repercussions of doing so. And unfortunately, I didn't find out about this until today. I think she viewed it as separate from the non-payment of rent case and thought that she had handled it properly herself. So as we sit here today, she did present a payment plan. She owes September rent. She had a acceptable payment plan to catch that up by mid-October, as well as pay October rent by the end of the month. But now she's possibly homeless with small children who are, still lost their father this summer, and it's just kind of tragedy and trauma on the family if that's the result of this process.
Mr. Fink.
She turned in a notice to vacate saying she'd be out on the 19th. She put her keys in the drop box. The landlord, with a notice to vacate and the keys, took possession of the unit. It was essentially vacant. I'm not saying it was empty, but from our perspective, possession has been surrendered. The landlord has taken possession and reasonably took possession. It's not an unlawful ejection. And she did also turn in a form under the not under VAWA, but under the statute, asking to be removed, I think, under the state statute. But we have possession of the unit because she surrendered possession.
I don't know, Ms. Bauer, that I can order them to put her back in under these circumstances. I mean, it is kind of strange, but she voluntarily gave up the unit there was nothing that the landlord.
Well, I basically bought this roof over the internet, which wasn't something I'd ever done before, but it worked out real well. I was scrolling through Facebook and I found this ad by the metal roof
Did to coerce her or to move her in that direction.
I don't know if you want to speak to her directly, but she thought that she was complying with the process that was necessary to have her rehoused. She did not understand that she was completely giving up. And I would say that my conversations with her did not align with her believing that she was giving up, because she was talking to me about how she was going to catch up her September rent this whole time. So it's, and also it doesn't really meet the VAWA, the conditions of VAWA, but she was given this form by the office to fill out. So I think it was a very confusing situation for her, and there should be some consideration for her confusion.
Well, yeah, certainly. I mean, I would have, in looking at it, if she had, say, turned in the keys, but they had not yet taken possession, that might be one thing. Or, the landlord had a judgment, they were issued a writ. That's one thing. I'm not sure that on a possession case, where I've not rendered judgment, but then the tenant has voluntarily surrendered, I don't know how I put her back in, if you're following what I'm saying. I mean, I get it if the landlord had done something during the course of that process, this process, that would lead her to leave or to surrender, but that's not what has transpired here, from what I understand. I mean, the only thing that's leading her to do that is rightfully or wrongfully, but it's not the landlord that's causing the angst.
Your Honor, if I could just say one more thing, Your Honor, I don't think she would have turned in the keys on the 19th if she hadn't believed that that was what she needed to do to be rehoused. And I think that information did come from the landlord. Nodding her head, yes.
Your Honor, I think there's no reason not to believe Ms. Bauer when she says her client made a mistake, but yet she surrendered possession. And by the way, Your Honor, I've got some photographs. I'm looking at an empty living room. She surrendered possession. She's vacated the unit. I'd like to submit an order of dismissal that includes the line that defendant surrendered possession. It may be there's some relief for her somewhere in reapplying for a unit or seeking some assistance in finding another unit, but she moved out. My client has possession. I think this case is moot.
Yeah.
Your Honor, if I could just say one more thing. Ms. Weatherspoon was homeless when she moved into the unit, so she never had a lot of furnishings, and she didn't remove the belongings that she had from the unit because she didn't realize that when she turned in the keys that she was essentially surrendering the unit.
Your Honor,
I don't know how that's.
I don't want to prove the case, but these pictures don't back that up. And I'm not saying anything about Ms. Bauer, and I think she is reporting what she believes to be true, but the photographs don't support that. And I also think it doesn't matter. She surrendered possession. We all agree.
I don't know that there's anything I can do. The issue of possession by her actions has become, and I think that's probably true, that it's now moot. I don't, this case. I mean, okay. She did the act.
I'll submit an order.
All right. So what I'm going to do is I'm going to dismiss this case. The issue is moot. the provision will read that defendant did surrender possession of the property.
Thank you, Your Honor.
All right.
Thank you for listening to us, Your Honor.
All right. Thank you. Huron Vista versus Giovanna Nesbeth. She was on, there she is. All right. What's the claim in this case at this point?
2871 is the total.
I had put in a money order for $350 inside of the mailbox today.
When did you do
before I went
that?
to my daughter's school. So maybe you haven't got
Today?
an update in regards to that, but
So what about the rest of it?
okay. So in regards to the whole COD thing, now I had conversations with Ms. Sheena in regards to when I was paying the amount back, but she never gave me a response back to the email, so I can know what to do if I am still able to be a part of the program or not, because I've reached out to Sarah as well just to try to help me with $500 so I can get down to the 1623, but I haven't got a response back from them. But if by today's date I don't know anything about the forgiveness plan or anything like that, I need to know. You understand what I'm
eligible?
saying?
Yeah, I got you. Is she eligible for the program?
She has never gone in to talk about the program. The note that I have is she has not been in to talk about a payment agreement. She said she was going to get help from a church, and it is possible to do an agreement. Your Honor, what I'd like to do is have a judgment extend the redemption period to the 13th with a note that the parties can submit a COD. Have you give her the terms of MCR 4.201, and that'll give her some incentive to get it done.
All right. You understand that, ma'am?
I actually, it was kind of fast. I mean, it's in my AirPods, so I kind of hear, like I kind of heard like the MR something 15.
Yeah. Okay. So here's what I'm going to do. You're not disputing the amount that's owed. So I'm going to issue a judgment for possession with that total amount of 2871. So we won't go up because October is right around the corner, right? And
yes.
I'm going to extend, normally you would have until the 6th of October to pay it. I'm going to extend it to the 13th, a week out. You need to get into the office, and I'm not going to have any objection if you work out a payment plan or change this into a conditional order of dismissal to allow you to get this paid off.
And that's for the whole 28?
Yes, ma'am.
Yeah.
All right, but the object is that you need to get into the office to work out a payment plan that allows you to pay your rent and pay this off. That's what I'm trying to give you the chance to do.
Okay.
You got it?
Yeah.
So,
so I'm not part of the program at all, so I would have to still pay the 1623.
Well, I'm not saying that you're not part of it. I'm saying it's got to be formalized into writing. So you got to get into the office, okay? Okay, and talk to them and try to work it out.
Okay.
Okay, got that?
Yes, I do. Thank you so much.
Okay, and so you would have 3 business days to think about this after any signing of the conditional order of dismissal. And if you believe that there's some mistake, some right you didn't assert, or some other confusion on your part, you'd have those 3 business days in which to ask the court to set that the conditional order of dismissal aside.
Okay.
Okay, but Ms. Nesbeth, understand, you got to get into that office and work it out, okay?
No problem. I'm about to get ready right now.
Okay, all right.
Thank you.
All right, Ms. Nesbeth, you have a good weekend.
You as well.
New Park Ridge Apartments versus Sherry Tubbs. Hello.
Hi,
What's your name?
Sherry Tubbs.
All right. You like Mickey Mouse?
Probably.
Never mind. I'm just looking at your shirt with Mickey on.
Oh.
How you doing? All right, where are we on this?
I think we're ready to talk about the terms of a COD.
Okay. All right, go ahead.
I have documentation that Ms. Tubbs or someone has done an address change with the United States Post Office for Mr. Gardner. You remember, Your Honor, this is.
Yes.
Mr. Gardner had her place listed on the sex offender registry. Regardless of whether he was living there at some time, he's not living there now. She will not allow him to live there. If he comes there, she will call the police. She'll agree to have him trespassed. Her two sons, whose names are
Jimmy and James.
Watch what chia seeds do to stuck poop.
See the sharp turn.
What's her last name?
Johnson.
Jimmy and James Johnson may not live there or visit. She'll comply with the terms of the lease. I will notify the Ypsilanti Police Department that Mr. Gardner does not live there, that his address on the sex offender registry is incorrect. I'll provide them a copy showing that that's no longer his address so that they can take care of the enforcement. If she does all of those things, this matter will remain dismissed. She has to do all of those things for 1 year.
Yeah. I too want to apologize for the last time I was here, intoxicated, remember?
I remember.
Oh.
We were wondering if
you were what, a 0.224. I remember.
Okay.
And you know, when you get in touch, you just talk. I know you just say stuff.
And I should say that if the landlord holds her responsible for the court costs, that she's going to have to make arrangements to pay those. But
okay,
and I don't know if they are plans on that, but they want her to be able to stay. She just has to take care of business.
Oh well.
Okay, and you understand all those terms?
Yes, sir. I do.
All right. You have any question regarding any of that?
No, I did not.
Would you give Mr. Fink permission to sign your name to the conditional order of dismissal if it meets those same terms?
Yes.
All right. I do have to advise you, since you're unrepresented by counsel, that from the time of my signing, you have 3 business days to think about it.
Okay.
If you believe that there's some legal reason, some misunderstanding, some confusion, or some right you didn't assert, you'd have to file a motion with the court within that time frame.
Okay.
Okay, you understand all of that?
Understood.
Any other questions?
I have one question.
Uh-oh.
You really have 33 grandchildren?
32.
32.
You have 32 grandchildren.
Twice what I have.
That
5 girls and 32 grandkids. I know.
Okay. So, well, Mr. Fink got a question. I got a question. You didn't have a beer for breakfast this morning.
No.
Okay. All right.
No.
Just thought I'd ask. All right.
Okay, thank you.
You take care. Have a good weekend, but not too bad. You remember what you told me about? Because I told you weren't supposed to drink.
Yeah.
Coming in here. What was your answer to me?
I said I wasn't going to drink on the 26th, but I might have a drink on the 25th.
Okay, you remember. Okay, all right. Have a good weekend. Actually, I think it was, I won't have a drink until the 27th. So it wasn't like if. Sparrowwood Apartments versus Regina Agnew. Uh-oh.
Nervous. I need to do one big cough and I can't right now. Hello, how are you?
Ma'am.
Mr. Fink.
That's me. I'm one of the Mr. Fink.
All right.
When you two get finished, let me know.
All right. Would you like me to state my name for the record? Look, I know.
I don't know that I can stop you. State your name, please.
Is that right?
To who?
Ezel?
Ezel?
Yeah.
Yes.
Oh.
Put all my business out.
He's a good man.
I know.
He was a good man.
Resting in peace.
Yeah, he was a good man.
Yeah. Father-in-law.
And I sit here on the bench and read the paper, feel like a third.
My mate name is Johnson. My Johnsons are good Johnsons. So you said that like you, well, Johnsons that grew up on Ainsworth. So my dad, oh yeah. I
have no idea.
When I got here, and you just kept on walking. So I thought maybe Robert told you to come in here and put the gloves on. But I'm gonna say my name for the record. Hi, Your Honor. My name is Regina Agnew.
Yes.
My sister wanted to hang out. She's in town visiting. And I told her, I said, I gotta go see my guy. She said, who's your guy? I said, the man that wear the black robe and have a gavel. She said, oh, you didn't tell me about that. I know you didn't. My dad gonna be looking down there. I said, you know, I was on.
You're on Zoom, you know.
I know.
Okay.
That's not, I'm just, my dad looking down, that he's in heaven, so. All right, come on, we can proceed.
Okay, all right.
Yeah, by the 6th. 1509.
Well, I paid 409 today
Okay, so that'll take you down to 11.
to 1100.
Yeah.
And I jotted some notes down.
This
I did a hardship with my employer, so that will direct deposit into my account. It said the 29th. So that's why I said the 30th, you know, how the banks take.
Well, I'll make this the 13th and you do the rest with Robert.
The
Well, you
1100.
work out any.
You all right. I'm so glad you know my father-in-law. Yeah. Thank you.
Your Honor, we've got a consent judgment.
You.
Also rent in the amount of $1,279, cost of $230 for a total of $1,509, but she paid $400 today.
409.
409, so she's down to $1,100, assuming that payment clears.
It will. It did.
Extended the redemption date to the 13th. This is a possession and money judgment. And as soon as you sign right there, the judge is going to tell you the 3 days you heard him tell other
Just
people.
need my glorious signature.
I just need your Regina Agnew right there.
I know,
Your
right?
Johnson Agnew.
Yeah. You have a great look.
Yeah. They're just good looking.
That's all that matters.
Yeah.
Raised to keep it good looking.
Who'd you live next to?
Well, my dad, who, you know the wife?
Yeah. You live next to the Rices? I know Grady and I are saying.
Oh, okay.
I used to blame him for this. I thought it was from him processing it.
Oh.
Turns out my kids have it too, so I don't think it's Grady's fault anymore.
Well, I'm from, I came out of Belleville High School.
Sorry.
Sorry, Tigers all day. See, roar. You know, that's that tiger roar.
Are you okay?
Yes. Oh, someone fell. Oh my God. You need a hug.
Can you get up?
Yes. Well, my grandmother, my grandparents. Yeah. You know the Johnsons? My dad was Ronald Johnson.
Oh, Ron Johnson.
You know Ron Johnson?
He's a graduate of Gypsy High School in 72.
And you know it. You know my daddy.
Of course I do.
You all right.
Yeah. Excuse us.
You know my daddy was a good man.
Yeah, he was.
Yes. His wife passed away, which was my mother and my sister.
Go ahead. Call this one for today, ladies and gentlemen. If you like this content and you're not a subscriber to this channel, please do me a big favor and subscribe to the channel and help the channel grow. I'm not really interested in monetizing. I just want to see the channel grow and do better and keep the positive attitude going on. So that's it for today, ladies and gentlemen. Ta-ta and ciao ciao. I will see you guys on the next one. You all have a wonderful evening.
scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fixing your hour, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's